Great day, Steve Stoller. It's KingCast here, otherwise known as Parker Doe. Welcome to another installation of KingCast Law, Justice, Politics, and Journalism. Sir, you may not know me as Parker Doe, but you certainly know of Parker Doe's work, okay? Because when you came to the scene, and I brought this up in a video here, I had been getting, consistent responsive feedback from Derek Jackson, the black fella who was in front of you in the public information response team, the public information officer. So that prompted me to do this, Volvo side chat with you. And I said, what does an 850R have in common with you? A blow-off valve. Absolutely. See if you can hear the blow-off valve. It's hard to hear right because that's what you did to me. You, in violation of any and all precepts of open government and sunshine laws, you blew me off. So I'm going to ask you now. Let's try to reestablish a relationship here, a professional relationship, where you are responsive to the public. There's a couple of hearings coming up right here. See these? Mm-hmm. Tap, tap, tap. Well, I want to know what are going to be the constraints or policies and practicums for attending these hearings. Because as I'm going to show you in a minute, there's a situation that happened before where we could not find out what was going on in terms of anything with the court, basically the policies and procedures were changed in terms of credentialing that Derek had laid out for us, right? Yeah, that's right. So let's take a look at some of that, right? Because I asked you back in May 22nd, right? I said, I'm concerned about Kelly Fletcher because she's doing this talk about how her son's going to come in and do some burnouts in the parking lot and all that stuff. And I was concerned about that because it's irresponsible and it's threatening conduct. Meanwhile, these Metcalfians are saying that I'm engaged in threatening conduct. But I mentioned that, and I was concerned about, that. And then I also asked you, I said, second, I am told by a harasser who identifies himself as Jason Mill that no independent journalist will be allowed to bring pen and paper into the overflow rooms, okay? Tap, tap, tap. And I said, I need to know, right? And then you never answer me. So then I says, you know what? Your failure to answer me tells me everything I need to know. Tap, tap, tap. So there's that. But then there's more. There's always more with KingCast. On this one, on the mandamus rehearing, there's a procedural defect, but I cured it. I said, these matters are substantial public concern. I've addressed the procedural defects, right? And I said, look, gosh knows His Honor has a handful to deal with, but it remains my contention that this is manageable with less restrictive means as indicated throughout the country in cases like Rodney King, South Carolina versus Rick Chow, Georgia versus Michael in the Ahmaud Arbery, California versus O.J. Simpson, Minnesota versus Derek Chauvin, Wisconsin versus Rittenhouse, and many more, right? So, I had a pseudonym, and I said, look, I have to use a pseudonym because these Metcalf people are hounding me while saying that I'm the one that's doing the hounding. Okay, they're insane. Now, let's get to the relevance of all this. Because guess what? That mandamus appears in the motion for new trial. It does. And in that motion, the team is discussing things right here. They go through the whole problem here of having ambiguous direction in terms of what's going on with court procedure, right? But right here, the point is underscored by a proceeding that unfolded outside of the defense's knowledge. Before trial, a member of the public filed an emergency petition for writ of mandamus. That'd be Parker. That's me. Tap, tap, tap. So, yeah, I filed that. There was a procedural defect, which I cured. And I didn't have there was confusion over the email address, but whatever the case, I served it to the court and to everyone there, but the court never forwarded that to the defense team, right? That's what they're saying there, right? That's a problem. The defense was left unaware. that a member of the public was contesting the very closure at issue, and that the state knew of it while the defense did not, both corroborates that the closure was real and confirms that the defendant had no opportunity to litigate or object to it as it unfolded. Yes, the record of that proceeding is, moreover, among the materials in the court's file that the court placed under an oral protective order, unprecedented, so that proof of who was and who was not notified is itself withheld from inspection. A further reason these facts must be developed at hearing. Tap, tap, tap. And that's the video I did about the dog ate the homework for Judge Roach. Right. And this is precisely the case. The court restricted public access on its own motion. Right. Defendant had no contemporaneous opportunity to object to closure. The structural error is thus preserved and timely raised, and defendant is entitled to new trial without a showing of prejudice. So, people want to get on KingCast, that's me, Parker Doe, saying I don't know what I'm talking about. And that's false. I've been a constitutional scholar forever. You go back to Ohio, read State versus Cheryl Lesson. I was working for Terry Gilbert back then, First Amendment case, flag burning. They tried to go after her. We won that on appeal. Guess who wrote most of the appellate brief for the Supreme Court? This guy. So, before I sign off, there's a couple things that are very dear to me. Sobs, right? And free press. I got this part covered. This part here, that's up to you. We're going to get it straight. Have a good night. I look forward to your response, Steve. Thank you. Honestly, what does one do with people who abuse their power this way? I just don't know.